All right, all right. Welcome back to my lost, not to my lost stream, but welcome back to my live stream. For those of you who do not know me, I am Boss Attorney Bree, and here on my channel, we cover lawsuits, including trademark lawsuits and other celebrity lawsuits going on in the world. I have been MIA recently due to the fact that I just came back from Mexico and then I got a cold when I got back. So I got a little bit of sick, but we are back and live streaming again. And today we are going to be discussing a trademark lawsuit. I'm sorry if it's a bit tough for me to get through this. Like I said, I am recovering from a cold, and I also just was on live stream all day over on Legal Bites, who is covering the Johnny Depp trial. So if you're interested in the defamation and things that go on with those lawsuits, make sure you go over and check out the Legal Bites episode. And there's also some other lawyer YouTubers streaming it as well if you're interested in finding out in the defamation case, and that includes Emily D. Baker and Rakeda Law. But I was on Legal Bites today, so make sure you go and check out her live stream if you are interested in the defamation case. Let me know where you guys are watching from. If you are new to my channel, please make sure to subscribe and make sure to hit the like button for the algorithm. Like I said, it's probably going to be a tough stream to go ahead and get through today, but we are nonetheless going to do it. And just give me 1 second right here while I get my life together here on this stream. And we can go ahead and jump right into the actual lawsuit that we're going to be covering today. Um, like I said, we're covering trademark infringement today. And I know a lot of people on my channel like to see the trademark infringement and see what's being copied. Today, we are not actually covering usually, we cover new lawsuits where someone is filing against another person for copying them. But today, we are actually covering a lawsuit that was filed in 2018. And so it has recently resolved. And we are going to be talking about two beer companies. So if you guys are just getting off of work and you want to grab a drink to enjoy this trademark infringement, make sure to do that. And let's kind of hop right into what's going on. All right. And so we have a couple of people in the chat. Thank you. Welcome to the live stream. Make sure you hit the like button. We are going to be talking about this case here. Here we go. We're going to jump right into it, guys. So today we are talking about Stone Brewing Co. or Company versus Molson Coors. Many of you might know them as Coors Brewing, very popular beer company. Let me know if you guys are beer enthusiasts, if you drink IPAs. Do you think IPAs are real beers? Do you just drink regular beer, or do you not just mess with beer at all? I personally do not drink beer, but I did think that this was a very interesting case that would be good to go over on my channel. And so, like I said, this is between Stone's Brewing Company and Molson Coors. And what they're suing for is trademark infringement, false designation of origin, trademark dilution, unfair competition, and declaratory relief, which is basically asking the court to determine that this company, that Coors, is infringing on Stone. Before the lawsuit is basically even done. So that doesn't necessarily happen here, and this is why we are covering it from the end. So, like I said, this case has already been resolved. So the complaint was filed, the answer was filed. There was a couple of motions going back and forth between the companies, and then they went to trial, and a jury actually came to the conclusion of whether these things were similar. As we go through the complaint, we're going to get down into the difference of the cans or the trademarks that are being used, and let me know whether you guys think that it is similar or if you do not think that is similar. So let's just hop right into it. We are talking about Stone Brewing Company, and they're also known as Gargoyle. So sometimes they may refer to themselves as Gargoyle. And then it's also brought between Molson Coors Brewing Company. I'll probably just call them Coors, or Miller Coors, because that's what most people know them as. And we're mostly going to go through the answer today because it has like a lot of the facts in there. We're also going to take a look at the complaint because the defendants in this case, of course, tried to get it dismissed, and they also filed their own counter complaint, or their own counter complaint. They had some things that they wanted the court to declare as well. As we know, that didn't happen because they ended up going to trial, and ultimately, spoiler alert, Miller Coors ends up losing. But we're going to talk about what arguments they actually had and why they lost, and how much they need to pay Stone Brewing Company. See how much they need to pay Gargoyle, right? All right, so let's see what the complaint has to say. So, Plaintiff Stone Brewing brings this trademark action to halt Defendant Miller Coors' misguided campaign to steal the consumer loyalty and awesome reputation of Stone's craft brew and iconic Stone trademark. So they have just the word Stone trademark for their beers. Miller Coors recently decided to rebrand its Colorado Rockies themed Keystone beer as Stone, which is the exact same name as the plaintiff, right? Simultaneously abandoning the Keystone's own heritage and falsely associating itself with Stone's well-known craft beers. And that's something that's really important to note in this case, is that Stone's Brewing is actually a craft beer, and I believe Miller Lite is just a regular beer. I'm not sure if they're rebranding the Keystone to be a IPA or a craft beer, but Miller Coors is mostly known in from my recollection and what this complaint is saying, for their regular beers, while Stone Brewing, they feel like they're a company that kind of jump started the whole IPA and craft beer style of beer. So that's also a very important note, and to see how they're kind of, in Keystone's opinion, stealing their craft beer and their creativity and trying to steal the same name that they have. So, since 1998, the incontestable Stone registered trademark has represented a promise to beer lovers that each Stone beer brewed under the Gargoyle's watchful eye is devoted to craft and quality, like all gargoyles. I don't know why they chose gargoyles to be their little mascot, but apparently it works for them. It is slow to anger and seeks a respectful live and let live relationship with peers and colleagues, even those purveying beers akin to watered down mineral spirits. But Stone and the Gargoyle cannot abide Miller Coors' efforts to mislead beer drinkers and sully or steal the Stone trademark and what it stands for. And so, what I noticed with this complaint is that this company is a craft beer, and they tried to be really creative in their writing for this complaint rather than just kind of putting the facts out there. They're trying to tell a story and talk about their gargoyles. And I'm sorry if I trip over some of the words today, guys. I've been on live all day. So it may be a little hard to read through this complaint, but just to let you know, that's why some of the wording may not make sense. Is either I'm tripping over the words, or these people are tripping and kind of trying to make a story out of their introduction or their words in their complaint because they're trying to be creative, I guess. Okay. Stone beer is beloved by millions of beer drinkers across America. Resolute and fearless, the brewing has always stood for a philosophy and approach that defies watered down orthodoxy of big beer companies and their fizzy yellow offerings. As big beer has stumbled in recent years, the Gargoyle have thrived. Stone is one of the most recognizable and popular craft beer brands in the US and global standard bearer for independent craft beers, with sales in all 50 US states and across 5 continents. So they're basically trying to say, hey, we're a popular craft beer. Stone's rise has not gone unnoticed by the largest beer company in America, Miller Coors. Miller Coors has long coveted the Stone mark, but has been blocked from using Stone centric branding because of Stone's incontestable registration. And in 2007, the U.S. Patent and Trademark Office forced Miller Coors to admit that using the mark Stones to sell Keystone would infringe on Stone's trademark, which is why they're bringing this lawsuit, because they're saying that Miller Coors knew that Keystone already had this trademark, so they shouldn't be trying to use shouldn't be trying to use Stone as their own trademark. Let me know if you guys think that them shortening Keystones, Miller Coors shortening Keystones, should not be considered as changing their trademark substantially. They literally dropped the word key and is only trying to use Stones as asserted by Stone Brewing Company. So let's pop back over and see what they're talking about. So they knew they shouldn't have been using the trademark. Yet in 2017, Miller Coors marketing executives decided to try again. Not long after Stone co-founder Greg Koch Coach doesn't matter publicly announced that the gargoyle would never sell out. Miller Coors began plotting to rebrand Keystone as Stone or The Stone. Miller Coors has since followed through on the plan and recently relabeled its products and launching Stone centric advertising. So they basically dropped the key and they're only going by Stone. The gargoyle does not, they keep referring to themselves as the gargoyle, and I cannot take it serious. The gargoyle does not um, continents with misdirection for consumers, nor does it support those who would disavow their own Colorado mountain heritage to misappropriate another's ancestry. Stones accordingly brings this action to help usher Keystones back to the Rockies. They basically want them to start using their own name again and to stop copying theirs. Should Keystone not willingly return, Stone intends to seek expedited discovery in aid of a preliminary injunction, as well as permanent injunctive relief, declaratory relief, damages, costs, and attorney's fees, among other remedies. So, again, they are going at it with their creative language to try to show that Keystone or that Miller Coors is copying their Stone trademark, but I don't understand why they have to try to write it so creatively. Like, just get to the point. It's very unnecessary, some of the stuff that they're saying. So, I'm going to kind of go past the parties because we know who they are. And then the jurisdiction and venue. This is brought in the Southern District of California. So it's a federal case because it's a federal law under trademark law. And of course, they have some state claims in there, but the state claims are based on the federal trademark law. It's just the state version of the trademark law. So let me know what you guys think so far. We're going to get into the actual cans that they're saying and the boxes that they are saying are infringing on their actual trademark here in a second. But throughout that, we're going to go through some of the facts that Keystone wanted, not Keystone. Ooh, look at me mixing them up already. That Stone Brewing wanted us to know why they think that Coors is copying them. So we're going to go through some of those facts, and then throughout those facts is going to show us the Stone Brewing's branding, and then it's also going to show us Coors' new branding that is supposedly infringing on the Stone Brewing's trademark. So let's pop back into the complaint and see what's going on here. They want to establish the foundation of Stone. Before it grew into an internationally recognized craft beer brand, Stone had its origins in the creative fermentation in California in the 1980s and 90s. After a few years of trying to commiserating on the bleak state of the American beer market, the founders of Stone Brewing, decided to take matters into their own hand. Greg and Steve made plans to open a brewery that would be defined by an unwavering commitment to quality and sustainability, holding true to the art of brewing bold, flavorful beers. That's when Stone was born. It says over the course of the next 4 years, Stone signed a lease on a small warehouse that turned into a brewery, and Stone IPA was born. From Stone's earliest bottles to the first website and delivery trucks, the Stone mark has signified Stone's rebel culture of creativity, quality, and independence. They show us a picture of some rocks. Uh, and then we move on to how Stone starts to develop in its own being. The new brewery opened in Escondido, Escondido, California of 2005, just before Stone's 10-year anniversary. Is in a stroke of innovation, Stone also opened the first Stone Brewing World Bistro and Garden, which shattered the brew pub mold with local organic ingredients and a seasonal menu constantly inspired by fresh worldly cuisine and the slow food movement. Now they want to move on to what Stone Brewing is today. Today, Stone is the ninth largest independent craft brewer in the United States. So they're just trying to establish that Stone Brewing is popular and it has a trademark, so we don't want Coors coming along and stealing their name. Presiding over a rapid expansion of the craft brewing industry from 800 breweries in 1996 to more than 5,000 today, Stone has maintained its commitment to true independent craft and sustainability. So, despite the market growing with craft beer, they're wanting the court to know that Stone Brewing is one of the most popular. It started when the movement for craft beers was little, and now it's grown bigger, and they are still the ninth biggest one out of all the brewing companies that exist in the United States. So let's pop back over to the complaint. Do. Stone's beers are sold in thousands of stores, bars, and restaurants throughout the country, including at major grocery stores and retailers. Instantly recognized by Stone, the registered trademark name, Stone enjoys exceptional customer loyalty and engagement with a devoted fan base unrivaled by other brewers. A sampling popular Stone beers appear like this. So this is what Stone Brewing, the plaintiffs cans look like. As you can see, they have Stone pretty prominent on the can. You can argue that this logo has a bearing on what the can actually is, even though these logos are a little different. I guess you have the gargoyle standing back on this first green can, and then on this yellow to the last three cans, they have the gargoyle kind of in your face. But Stone is the biggest part of the trademark. You see the IPA to kind of explain what they're actually selling, but for the most part, Stone is the biggest part of the can. So I think that shows us that Stone is their trademark and they're using it to whereas people, oh, you guys can't even see it. Oh, yes, you can. Okay. Yeah. So they're using it to whereas people see Stone as their actual trademark. So let's pop back over. Um, Even as Stone has expanded its range of offerings with bold new flavors and numerous seasonal beers, the Stone mark has remained constant and unchanging identifier of Stone's reputation for quality and commitment to the craft. Stone enjoys exceptional customer engagement ratings on social media with scores nearly double the nearest craft beer. Loyal customers have even been known to commission tattoos of Stone in homage and then travel to the Escondido brewery to proudly show off their ink. So they're saying that people support them so much that they go and get a tattoo of the Stone logo. And then when they go to the origin place of this company, they're kind of showing off their tattoos like, hey, I really support this craft beer brand. That is extreme loyalty, if you ask me. But again, like I said earlier on, I am not a beer drinker. So I do not know how to be that loyal to a beer brand. But apparently, these people are very loyal to their beer brand. Let me know if you guys drink beer like that. If you find it, if you will be that dedicated in order to get a tattoo of your favorite beer. All right, so let's go on to the defendants, Miller Coors, and their origin of the Keystone beer. And like I said earlier, Miller Coors is one of the largest beer companies throughout the United States. So when it comes to trademark, it's always very annoying for big companies to come after smaller brands and kind of steal their branding. Stone Brewing would be considered the smaller brand because Miller Coors is known across the United States and probably internationally, and they're one of the biggest beer brands that there are. And then on top of that, they're kind of taking a brand that a small company created and using it to help promote some of their products, or maybe if Miller Coors was falling off a little bit, they decided, hey, this Stone is doing pretty well, and we originally called our cans Keystone, so maybe we can do pretty well if we use the same name. Now, when we get into the answer, Miller Coors is going to say no, they're not rebranding to just Stone, but as we go through this answer, and then when we get into the complaint, you'll be able to see what similarities they have and why a jury could find or possibly find that this is infringing on Keystone's, I mean, not Keystone's, but Stone's Brewing's trademark. So let's pop back over to the complaint. Let me know what you guys think. Let me know if you've ever tried Miller Coors or Stone's Brewing, and which one do you think is better. Like I said, I don't drink beer, so I don't really have an opinion on that matter. All right, Defendant Molson Coors is a multinational beer conglomerate formed after a series of mergers involving Coors, Miller, and Canadian brewing giant Molson. It goes into more of the details among dozens of brands in its portfolio. So they have multiple different brands of beers under Miller Coors. Miller Coors sell domestic larger brands Keystone and Keystone Light, which is the brand that is at question in this lawsuit. Since its inception, Miller Coors and its predecessors have sold its Keystone sub-premium beer brand in cans with a primary Keystone mark and prominent imagery of the Colorado Rocky Mountains. The name Keystone is the name of a popular ski resort town founded in 1970s in Colorado. The mountain range depicted on the can is styled after the Wilson Peak located in the Rockies. In doing so, the Keystone name served to remind consumers the brand Colorado roots and ties to the parent brand Coors. These ties apparently no longer bind so tight. So they're basically throwing shade and saying they don't really care about Keystone anymore because they're too busy trying to steal Stone as the new trademark. And they also said they also relocated and they're no longer located in the Rocky Mountains, and now their base is in Chicago, Illinois. This may explain the company's new insistence on dropping Key from the brand. From its brand in favor of Stone in an effort to chase the craft market and Stone in particular. All right, Miller Coors big beer brands like Keystones have suffered most from the rise of tasty brews like Stone. And again, like I said earlier, the plaintiff in this case is a craft beer. And if you know anything about the beer industry, craft beers, I maybe if you don't know anything, because I don't really know anything, but it's supposed to be like a more flavorful beer, not the normal just grains or whatever else you put in beer. It's not just normal beer, it's a craft beer, so it's supposedly special. Sometimes they're sweeter, and they're saying that Miller Coors, who is a big giant brewing company, is trying to kind of capitalize on the new IPA and craft beer market by stealing this well-known craft beer's name. So that's important to know. I don't remember reading whether their Keystone beer is actually a craft beer or just a regular beer, but they do want to emphasize that they are a craft beer and that Miller Coors is trying to capitalize on the fame of their craft beer in order to get more sales. As craft beer was on the rise from the late 1990s to 2000s, celebrating double-digit growth each year, Big Bear increasingly lost market share. From 2011 to 2016, Keystone Light sales dropped more than 25%. US Today recently dubbed Keystone one of the beers Americans no longer drink in a December 2017 article. So they're basically saying nobody wants to drink Keystone beers anymore, which would make sense because that's why they will rebrand into the Stone Brewing, which is very popular in the craft beer industry. So they're saying basically that, okay, they're losing momentum with their Keystone beers, which in 2017 is when they actually rebranded. And in December 2017 is when someone wrote an article saying that nobody no longer wants to drink Keystone. So that could be a motive right there. All right. So Miller Coor's renaming of Keystone to Stone marks an aggressively second phase to the company's pincer move against craft beer and Stone in particular. In April 2017, the company quietly announced that Keystone was to be rebranded to Stone. New cans, boxes, and logos were formulated to emphasize Stone as a primary mark. Since the release of the new design, Miller Coors has launched a viral marketing campaign that touts Keystone's self-proclaimed new name Stone. In recent months, the brand's Facebook and Instagram pages have scrubbed off the word key and filled with posts strategically placing Keystone beer cans so that only Stone, which they said they strategically placed the can so that Stone shows, which you will see in the answer that Miller Coors says that they are actually not copying them because key is still on the can. When we get into the similarity of the cans or the use of Stone as a trademark, which is what's going to be primarily shown, Stone Brewing is saying that Miller Coors is intentionally placing the can to where only Stone shows. So Miller Coors' argument that key is still on the can is kind of irrelevant because in their marketing, they're only showing the Stone. They're not showing it how Miller Coors is going to show it in their answer to this lawsuit. So I think that's very interesting. I didn't really catch that earlier, but now I see it. All right. So they show it to where Stone is prominently displayed to viewers with accompanying videos to match. These changes point unmistakably to the concerted effort by Miller Coors to capitalize on the goodwill and recognition associated with Stone's mark and brand. All right, in a glaring departure from Keystone's traditional brand, Miller Coors have redesigned the label of Keystone cans and cases to emphasize its shift to Stone. And here you can see where they're saying that they changed and copied them. Right here you see this is, oops, nope, don't do that. All right. Right here you see this is the old can and this is the rebranded can. And so the reason why they're showing it like this is because the plaintiff is saying that Miller Coors is putting the can out there to where it only shows Stone, and we'll see it in their marketing down below. But if you look on the original can, the old can, the Keystone Light, you can see the full name. It has the Rocky Mountains to kind of associate its origin to to Colorado. And now they just kind of shifted it to like a blank color, bright color, of course, with Stone super large on the can. Keystone's new can design overtly copies and infringes the Stone trademark. Indeed, Miller Coors has effectively admitted that this copying is intentional. Before the cans hit shelves, Miller Coors announced in an official blog post that it was launching a can that plays up the Stone nickname, a new self-proclaimed nickname that is. The new Keystone can display Stone as the primary brand identifier with no apparent hint of the traditional Keystone brand or its signature mountain theme, which I can agree with that. They came out with the main part of the can being about the mountains. They want people to know that they're coming from Colorado and all of these things. And now all of a sudden they kind of have this bland design that has no mountains on it. Um, and it's pretty similar to or it can show that they're only intending for the name to be Stone rather than Keystone, but we'll show you, or I'll show you when I get into the answer, what Miller Coors is actually saying that they're doing, because technically key is still on this can, but we can't see it. And the reason why what do you call it, the reason why Stone Brewing is so upset is because the key, they're not, Miller Coors is not trying to show the key, but it's on the can, but the way that they're doing their marketing is not showing the key part of Keystone on the can. So let's pop back over to the complaint and see what they have going on. All right. The rest of the new Keystone packaging conspicuously copies the Stone mark. Indeed, the new Keystone 30-pack omit virtually any reference to Keystone at all. Instead, the packaging is designed to create a wall of stone when displayed in stores. So as you can see, it just says stone, 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 which can make it pretty confusingly similar to the Stone Brewing's trademark, because they call their drink Stone IPA. So packaging and labels are critical to beer marketing, ensuring that brands stand out to consumers perusing the beers aisles in stores. The overwhelming emphasis of Stone on the new Keystone packaging is a declaration that Keystone has abandoned its roots in an effort to simply become Stone to consumers. But there is already one and only one, the true Stone registered trademark in the market. And what um Miller Coors is trying to be sneaky about this, because they're saying, "Oh no, key is still on the package," but we're doing our marketing in a way that you're not really seeing the key on the package. And so what will happen is that they will use that, and they will do that for 50 years, or not 50 years, for 5 years. And when the 5 years is up, they'll go to the USPTO and say, "Hey, look, we've been using this as in commerce for 5 years, and no one has confused the brands. I think that we should be able to get a trademark because it has acquired distinctiveness. It's not similar to the craft beer of Stone Brewing, but it's become our own new trademark." And so they're trying to be sneaky about this. We're going to get into it a little bit later about how they tried to file for a trademark and it got denied. But they know that this is these people's trademark. But they're trying to, in my opinion, they're trying to be sneaky about it and acquire distinctiveness in order to get the trademark and show, hey, no confusion over 5 years. All right. So let me know if you guys have any questions about trademarks and how to acquire distinctiveness, or just this beer trademark in general. If you came in late and you missed what the Stone Brewings can look like, let me know. I can go back up and show you what they're saying is confusingly similar. And this one is not necessarily the design. Sometimes we go over designs being similar, but this is just the plain use of the word stone. It doesn't have to be the same design. At the same time, Miller Coors has also launched an escalated advertising on social media attack to establish Stone as the new Keystone. And so, as we can see on their Facebook advertising, they are just kind of showing Stone. We can't play the video, of course, because these are screenshots. But it's starting off in the video of it just saying Stone. I'm sure they rotate the cans during the video to show the key part of it, but they're starting off in Stone. Again, on Instagram, they make a lot of references to the word Stone that Stone Brewing thinks is kind of misleading. Upon information and belief, Miller Coors has also purchased advertising on major websites such as ESPN.com, referring to Keystone as Stone, which mass advertising broadcasts the infringing Stone name beyond Keystone's immediate social media audience to a general public at large. Again, we see Stone. They're only showing the Stone part of the can right here. I don't know if you guys can see me highlighting that yellow. Um, it's only showing the Stone part of the can, but then on the side, they have Keystone Light on the side, but smaller, of course. Further, in recent months, Keystone launched launched and widely promoted a contest entitled "Hunt the Stone." This contest has been publicized in physical ads and via social media, showcasing Keystone's new can design and intent to abandon the Keystone name for the beer in favor of Stone. These new ads drastically differ drastically from previous ads advertising contests. So okay, this one has the original can. Oh, this is the old ad. How about I pay attention? Okay, yeah, old ad. Keystone Light, can hunt, find the orange can. And then the new ad says hunt the stone. Yeah. I think that they are kind of toting the line to kind of cross over to being recognized just as Stone. Like I said, because they're probably trying to acquire distinctiveness. And yeah, I cannot stream as long as I have before because my sickness is coming to me. All right, so let's pop back over to the complaint. Miller Coors has long coveted the Stone mark for years. Stone's incontestable registration has stood as an obstacle to the Keystone marketing efforts, preventing use of Stone-centric branding. Now, Miller Coors is willfully infringing the Stone's mark in a calculated attempt to dilute it beyond repair. And so, this is where we're going to get into the actual trademark that Stone Brewing has and what Miller Coors has done to try to also get a Stone trademark. In September 20, or I don't know, I keep want to say 2017, but it's not. It's way back before that. So in September 2007, Miller Courts applied to register the mark Stones with the USPTO for use in connection with Keystone Light. The USPTO refused to register the mark for the obvious reason that Stones was likely to be confused with Stone, their registered trademark, when used on beer. The USPTO's action explicitly cited the incontestable Stone registration as the basis for refusal, putting Miller Coors on formal notice of Stone's rights in the unlikely event it was not aware of them already. Tellingly, Miller Coors did not dispute the USPTO determination that its Stone mark would infringe on Stone when used in connection with Stone Light. Miller Coors instead abandoned its application, admitting that confusion with Stone beer was likely. So, since they did not respond to the office action, Stone is taking that as an admission that it would be confusingly similar. Not necessarily true that that would be an admission. They just decided that they didn't want to go ahead and fight the office action because honestly, it would have been pretty hard for them to overcome that refusal because Stone on Stones on beer, it's too confusingly similar. One is just plural, right? So they're saying that they knew about this trademark, and the fact that they knew about this trademark makes their infringement intentional. So let's pop back over to the complaint. Let me know if you guys have any questions on why this is happening this way, or what you would have done differently if you were Miller Coors. Miller Coors' deliberate infringement is likely to succeed in causing confusion. Not only does Miller Coors' new Stone branding copy Stone's mark verbatim, but the company's beers compete head to head in store aisles across the country and a high velocity beer market where consumers make quick decisions between a proliferating array of brands. The effect of even initial confusion are likely to be momentous. Momentous. Okay. So that's one of the big things about trademark. If you are shopping for something and people usually make kind of like hasty decisions, or it's a product that's not really expensive, it's easier to kind of prove infringement or confusion because people are making those decisions quickly and the prices don't differ that much. So let's say if the IPA one is only $3, but the Coors Miller one is $4, people are going to be like, oh, this is a little expensive for this, store, but maybe it's just a store. Versus if you're going into Louis Vuitton, you aren't gonna go to Walmart and see a Louis Vuitton for $30 and be like, oh yeah, this is completely real, right? You're gonna know. But when it's something that's such a small price, people don't generally pay that much attention. And when it comes to things like drinks, beers, wines, things like that, the price usually doesn't really differ all that much. Versus if you're buying a purse, it could be a high-end purse that's $600 or a high-end purse that's $2,000. You're going to pay more attention when you're spending that amount of money. So that's the argument that Stone is making here, is that, hey, when people are going to get their beer, they're kind of making hasty decisions. They don't have time to be like, okay, is this Stone the IPA or is this Stone the Miller Coors Keystone wannabe Stone beer? So they make that point for those reasons. All right. So beyond the new Stone cans, Miller has admittedly seeking to establish Stone as a trademark and source identifier for its new Keystone brand. If this gambit succeeds, a bar or restaurant patron asking for a tasty Stone brew will be just as likely to receive Keystone's watered down imitation of beer in its place. They are not kind with their words. Watered down imitation of beer. Miller Coors, they are coming after you. All right, the Stone mark has grown to the present strength because consumers trust that Stone will never let them down in this manner. In recent weeks, Stones have received consumer inquiries showing that Miller Coors escalated infringement is indeed brewing confusion. They try to use a lot of puns. Indeed, brewing confusion in the marketplace. In December 2017, for example, a consumer reached out to Stone to inquire about the brewery's new Stone Light product, a non existent beer that appears in Miller Coors' deceptive advertising. So, this is basically Stone Light is Miller Coors product, but Stone Brewing has confused it to be one of Stone's Brewing's products. So you can see how that can become confusing for people that's shopping for beer. And then they go on into the claims of relief. Of course, they're claiming federal trademark infringement. We're not going to go through everything that is required to show that because we went through everything that it's causing confusion, and the registration belongs to Stone Brewing already. All right, they're also claiming for a false designation of origin, basically tricking people into who is actually the creator of this beer. Hence, the person reaching out to them saying, "Hey, you guys made a new Stone Light," and Stone Brewing is like, "No, no, we didn't." And then we have trademark dilution, basically reducing the quality that people think of the beer as. And then we also have trademark dilution under the California law, which is the same thing, but it's just under state law. Unfair competition under California law. They're unfairly competing with Stone Brewing by making a product that is similar to theirs and confusing people basically and potentially stealing their sales. And then a declaratory judgment basically saying that they are infringing. They want the court to go ahead and make the judgment before they even go through trial. Okay, and of course they're asking for the court to enjoin the defendants from copying them, and then also seeking damages for the dilution, for the infringement, for the unfair competition, and they're also going to be seeking attorney's fees and anything else the court deems is necessary under this case. And so I'm going to pop back over to here because we have a couple of things in the chat. We have Dink and Fatal. Welcome to the live stream. Thank you for joining. Hi, Boss Attorney Bree and chat. Hello, welcome, welcome. We are gonna hop over to the answer soon. We went through the complaint, so feel free to re-watch if you missed it. And then we have the quality of course. I have so many questions now, and so I am not familiar with beer and the taste of beer. So if you have some insight on that, feel free to share it with the chat. Um, are Coors bad? I know they're a really known brand. I've known about them pretty much my whole entire life. But as far as the taste and quality, I don't know because I don't drink beer. I know that based off of this complaint, the Stone IPA is an IPA, a craft beer, and they have different flavors. But as far as the Coors Miller Light one, Keystone, I believe it's a regular beer because Stone Brewing has said it's a watered down imitation of beer in their complaint. So it must not be too tasty. Okay, so I'm gonna hop over to the answer, and we're just gonna quickly go over the answer because, of course, it talks about some of the same things that are in the complaint that the plaintiff filed, but this is basically Coors defending themselves. There are a couple of things that I do want to look into, just because Coors is not having it. They're basically saying that they are not copying Stone and that they are still going hard for Keystone, which was their original trademark. So let's pop on over to what they have to say. This is just their answer to defend themselves. So the main part is Stone Brewing's argument depends entirely on disassembling Miller Coors Keystone trademark, focusing only on the stone portion of the mark while ignoring the key portion that is prominently visible on both the cans and the outer packaging. And so this is where they're saying that they're being deceptive because, as you can see on the complaint, let me just pop back over here to show you how they presented it. They presented it with of course, their advertisement where they themselves is only showing Stone on the can. So rightfully so, Stone Brewing is upset. Then again, we have them showing Stone on the can only right here as well, but they have a little Keystone light on the side, but that's not the focus of the ad. The focus of the ads are the big letters that says to each their Stone. And they're showing purposely only Stone on their can, but they're claiming that Stone Brewing is dissecting their can to only show Stone, but they're doing it themselves in their own advertising. Again, welcome Stone, Keystone Light, very small at the bottom. Then again, a Stone so much a Stone so smooth it never cuts corners. Again, Keystone Light very small in the corner. It's the potential that the can does rotate, but they do want to focus on Stone, hence they're like catchy sayings with Stone on it. Again, here's their advertisement. This is their post. It looks like a picture to me, and they're only showing Stone. Again, only showing Stone. And then this is how Stone Brewing displayed the Stone on there. But what Miller Coors, what is it called? Miller Coors, yeah. They're saying that Stone is doing this on purpose, only showing the Stone part of the can. But as you can see in their own advertisement, they're doing that themselves. Okay. And then this is what the plaintiff's can looks like. Of course, Stone is the name because they're Stone Brewing. All right, let's pop back over to the answer. But this is what Miller Coors is saying that their packaging look like. So in their advertisement, did you guys see the can like this, or did you see it with them displaying stones? I saw it with them displaying stones. So let me pop back over and see what the chat has to say. Oh, that one's okay. I'm assuming you're talking about the beers. Is buying a website name before they get popular a good investment? Sometimes it can be. I know there's a lot of people that buy domain names and then they sell it to people at a premium. So they can either profit from that. If you plan on like starting a business but you have some time before you fully develop it and the name is available and you buy it, then yes, that's a good investment because if someone sees you in the development, they can potentially buy that domain name and then you have to pay them that premium. So if you're planning on starting a business, then yes, buying your domain name is a good investment. If you're getting it before anybody owns it, it should be about $12 a year if you get it on Google, which is pretty cheap. But if someone buys it and kind of holds it hostage from you, then they can charge you $1,000, $3,000, $5,000, however much they think that the name is worth to you. So, and then if you are also a person doing that, you can also charge that premium. Sometimes it's not really a good idea because you can be seen as like domain squatting and you could get kind of DMC taken down from it. But if someone just pays you for the name, then you profit. But if somebody strikes you for squatting on the domain, then people can just take it from you for free. So yes and no of it being a good investment. Well, it wouldn't really be free because they'll probably have to pay a lawyer to help them get the domain from you. All right. How to head, but we'll watch the rewind. Thank you. Thank you for stopping by. And you left a like. Thank you for liking. Just got here. So Angela Lansbury. All right. I still have not looked into that. So you kind of caught me there. So I will definitely need to look into that so I can know what you're talking about all the way. All right. So back to the advertisement. They're saying that they're not copying them because Stone Brewing is saying, hey, they're only using Stone to acknowledge their company. But then Miller Coors came back and said, no, look, see here, we still have key on the can and we still have key on the box. So they're lying. And that's from 2017. This case was filed in 2018. So that's why the advertisement is a little bit later. All right. And then so we have Stone Brewing raised these same exact issues to Miller Coors in 2010, but in spite of Miller Coors' rejection of the Stone Brewing's complaints at the time and continued use of Stone and Stones thereafter, Stone Brewing waited 8 years to file this lawsuit. And so they're basically trying to get into the argument of latches, like they knew, hey, they knew we were infringing, or they thought we were infringing back then because they told us about it in 2010. So So it's basically their fault in the fact that they waited so long to bring this complaint shows that we're not copying them. If you guys watched my Rolex video about the latches, the other company actually won on the latches argument, and that way they didn't have to pay Rolex any money. So basically, if Miller Coors can win on this as well, then they won't have to pay them any money. So that's why they're trying to bring up the latches defense, basically saying that Stone Brewing waited too long to bring this action. Instead, Stone Brewing has chosen only to include images in its complaint that misrepresents the look of Keystone cans in outer packaging. So they're saying this is the actual can, but a lot of their advertisement, they are just using the Stone side of the can anyway. So I think that they are justified in using it the way that Miller Coors is using it. And I am sorry, guys, my voice is going out. This cold is catching up to me. All right. So again, they're talking about latches. I think that was pretty much all I wanted in this answer. So let me know what you guys think as far as whether they're trying to pass their can off as only being Stone. Again, let's go back through the complaint. This is the plaintiff's can, and this is how Defendant's can was originally advertised, and now they have changed their can to be where are you? They have changed their can to be this. So it still says Coor Brewing Company and it has Keystone, but they make it as like two different words. But as you can see over here, it was originally one word, but now they can rotate the can to where it only shows Stone, which I think can show that it's copycatting. Or not copycatting, trademark infringement. Let's use professional terms, guys. Yeah, so all right, we have let's pop back over to the chat. Hey Bree, hello Jay Michael. Then welcome to the live stream. Thank you for stopping by and leaving a comment. Make sure you leave a like if you have not already. Latches is a defense akin to the statute of limitations. Yes, basically what it is, but not necessarily statute of limitations. It's kind of when a statute of limitations doesn't apply. And it kind of bars you from bringing the claim when you take too long to bring it. So usually it's especially when someone's taken a long time, but they knew about it, or it can kind of be an equitable remedy. So not necessarily statute of limitations, but it's an equitable remedy because you knew about it a long time ago. So you should have brought the case a long time ago because you're causing us to lose more money since you didn't bring it as soon as you known about it. But it's not necessarily statute of limitations. So yes. All right, no worries. Like and subscribe. Caught you on Natalie. Okay, thank you. Welcome over from Natalie's channel. Cool. Yeah, I've been doing a couple of collabs lately, so I know a couple of people are popping over from different channels. So I definitely appreciate you guys coming over. All right, so let me know if you think that the way that they're displaying this is similar, or do you think they intend for the can to be displayed like this or like this, the way that they're displaying it in all their commercials and their Instagram posts? And the way that the plaintiff is showing it. I think that they're intending for it to be shown like this, hence all of the things that they keep saying as far as Stone this, Stone that, their catchy little Stone fragrances. I think that I'm not fragrances, phrases. I think they really want to be known as Stone. Hence why they tried to trademark Stones in 2007. All right. So I really wanted to know what you guys think, but no one is leaving their comment of what they think. But we're gonna go ahead and go to the jury verdict because, like I said at the beginning of the stream, this case has actually already been litigated. It was filed in 2018. That's why you see a lot of the things in the complaint and the answer are from 2017 because it was filed early 2018. But this case recently was decided as of March 25th, 2022, which was a couple weeks ago. What was that, like 2-3 weeks ago? Um, and the jury decided this case. It wasn't decided by a judge only, it was decided by the jury. And let's go ahead and look at the jury's paper. We have the verdict form from the jury. So we're going to go ahead and look at it and see what they decided. All right. It says, we, the jury, being first duly impaneled and sworn in the case, captioned Stone Brewing. Let me zoom this in a little bit so I know I can't see, so I want to make sure you guys can see. All right. They were sworn in and they find as follows. As far as trademark infringement goes, did plaintiff prove by a preponderance of the evidence that defendant infringed on the Stone trademark? They answered yes, they do see infringement here. So that probably means that the jury thinks that Miller Coors intended to put their can in a way to only show Stone. I don't think it looks very good for them that they also filed for the trademark Stones in 2007 and then waited 10 years to start making it more prominently shown on their can. Again, I do think that they're trying to come up with an acquired distinctiveness argument in order to get Stone registered for their own trademark. So the jury said yes, they do believe that there was trademark infringement. If you answered yes to the preceding question, answer the following two questions. The amount of damages, or what amount of damages have plaintiff proved by the preponderance of evidence, if any, were caused by defendant's infringement? They said $56 million, not $56,000, $56 million based on infringement only. So this small company is going to be getting paid $56 million by Miller Coors. That is a very large reward in this lawsuit. Willfulness. Did plaintiff prove by a preponderance of evidence that defendant's infringement was willful? They said no. And so what does that mean? Since they found that the infringement was not willful, they are not going to have to pay punitive damages, so they won't be punished for copying their trademark, and they may not have to pay attorney's fees, or the attorney's fees might be reduced. I'll have to look into the willfulness to see. But if they prove $56 million of infringement off of making money off of the Stone alone, that's a lot of money. So, yes, they're not having to pay punitive damage because the infringement was not willful. And then it's just signed by the head juror. So what do you guys think about that award? It sounds like quite a lot to me. Looks like intent was to infringe. Why else not use the full name? I agree with that. The only thing about it is that technically they did use the full name on the can. They just separated it into two words to where you can turn the can to only show Stone by itself. And they purposely used it like that in their advertisement. So I think that they definitely messed up there as far as the trademark filing goes, and as far as the way that they're advertising it only as Stones. And then they admitted that yes, they did use Stones to promote their product. And since Stone Brewing didn't bring the complaint against them, then they must not have cared. So the jury here did not agree with the latches argument. Otherwise, Miller Coors would not be paying $56 million to Stone Brewing. So I just kind of wanted to pop over and look at the official jury entrance, or not the jury entrance, the jury verdict put in by the clerk. So this is official as of March 30th. So 2 weeks ago, less than 2 weeks ago. And it just basically says the same thing that the jury did decide on there. So it says the jury found judgment in favor of Plaintiff Stone Brewing Company LLC and against Miller Coors LLC. The jury found that plaintiffs did prove by preponderance of evidence that defendant infringed Plaintiff Stone trademark. Plaintiff is awarded $56 million. I cannot get over that amount, but it is a big company. But $56 million in damages. The jury found that the plaintiffs did not prove by the preponderance of evidence that the defendant's infringement was willful. And it was entered as of March 30th of this year. So pretty recent entry of judgment. And just for the heck of it, I am going to look up how much Miller Coors is worth. So I want to see how much money they have and if they can pay this. I don't think it's going to tell me. I don't think it's going to tell me how much it's worth. But anyways, they do have to pay that amount. Do you guys think that that amount is fair? I don't know. They had to present the evidence to show that they should have $56 million because of what they did, which is, I feel like, a lot of money for a brewing company. Let me see how much does, I don't know if this is public record. How much profit does Miller Coors make per year? Okay, here's something. The revenue is over 500 million. So I guess they could pay it. I don't know how accurate this thing is, but it says they make over $500 million a year. And it wants me to pay to see exactly how much they make a year. So they can pay $56 million if that is true, that they make over $500 million a year. All right. And then we have J. Michael. How did they quantify the damage? It'll be in the actual court document. So they actually went to trial on this. And so they probably had to show like how much their name is worth. And then they'll show how many of the cans that Miller Coors sold. And so if they made, let's say they made $60 million off of, that's probably not right. Let's say they made $100 million off of the sale of the Keystone beers under the new packaging. The court will decide, or they will say how much of that is actually profit and how much of that is actually like expense. And so whatever the profit is, they basically have to pay that to a Stone. I keep mixing up the names, to Stone Brewing. So they have to disgorge the profit. So however much they made off of it, they have to pay it. However much they diluted their value, they had to pay it. So that's how they determine it. And those documents would have been presented as like exhibits during the court proceeding. So that's how they have it. I don't have the documents of how they actually determined it or anything, but the jury would have had that evidence in the court case. All righty. So that is all I have for today on this case. And my voice is really going out right now. I plan on live streaming on Thursday, but hopefully I am feeling better and I am able to go ahead and do the case. There is a copyright case again. Is it a copyright case? A trademark case against Future and Sony. So I think I'm going to cover that on Thursday if you're interested in it. If you guys have followed me over from Legal Bites or Natalie Lawyer Chick, I will probably be popping into a Legal Bites live stream on the Johnny Depp trial. It's a defamation case. So if you guys are interested in that, make sure you go over and check out her channel. And I will see you guys in the next live stream. And I hope you guys have a good evening.